Hello everyone and welcome to video 3.1.10 for the Legal Studies guide. We are starting to get towards the end of Unit 3 Outcome 1 or Study 1. So only 4 to go after this and almost into sentencing, so no more principles of justice. Quote today is, "Be curious, not judgmental." Now this quote got a bit of a run recently when it featured on the TV show Ted Lasso, and Ted attributed the quote to Walt Whitman. It wasn't actually a quote by Walt Whitman, but I think it's a really good point that, if you maybe see someone doing something a little bit different or something that you don't understand, rather than immediately judging that person, and often what comes with judgment is then ridicule and jokes and things like that. It's actually be curious. Consider asking why they're doing something the way they're doing it. Consider engaging with that person and trying to learn a little bit more about them. You'll open your own horizons, and that can only take you further in this world. I'll get off my high horse now and talk about what we're here for, which is the need for legal practitioners in a criminal case. So we're focused on, in 319, we focused on the roles of key personnel, and that really focused on judge, jury, parties. And obviously, a key feature or a key personnel that's missing there is lawyers. And that's because they've got their own dot point. This is new in this study design, and it's particularly like this word is really, really important to focus on. So, the need for legal practitioners. So, why do we need them? We're going to link that to the principles of justice really well. It's still the same key skill, though. We're still analysing the roles of key personnel in a criminal case, so we need to be able to analyse what a legal practitioner does. And I'm hoping at the end of this, if someone said to you, "Hey, what do lawyers actually do?" You'll be able to say, "Hey, this is the role they play and why they're needed," really, really clearly. So, legal practitioners, what are they? Just a little bit of base knowledge. A lot of you will know this already, but just a little bit about what a legal practitioner is. And because we're talking about the criminal case now and not just the trial itself, making sure we have a broad understanding of, I guess, in a way, the different categories of lawyers that can exist. So effectively, trained lawyers will represent each party in a trial and throughout the case and manage each party's case. Obviously, for the prosecution, that is always a legal professional or like a police prosecutor who's trained. But usually, for more serious matters, we know it's someone from the Office of Public Prosecutions who will do the case work, and then a barrister, potentially a Crown prosecutor, who'll come in and do the presenting of the case. The accused person has the responsibility to retain their own legal representative. So if you're accused of a crime, you have to go and get yourself a lawyer. To the extent of, even if you end up with a publicly funded lawyer through legal aid, you still have to do the application for that. So it's not, it's not like a lawyer is grabbed and given to you. Even to get legal aid, you have to do that application, as we know. So prosecution, always lawyers. Or trained police representatives for summary matters generally, whereas you either need to represent yourself or go and get yourself a lawyer. And in terms of the two types of lawyers, we talk about barristers, who are the ones who turn up at the trial and do the presenting of the case. So they're like the rock stars of the legal world, where the silks get to become senior counsels, or what used to be called kings or queens counsels, and they're the ones that end up on the news. Really famous, TV shows built around their ability to present cases and have witty one-liners and all of that sort of stuff. That's in comparison to solicitors, who are the behind the scenes, so the ones who provide the administrative support and manage the case overall. And in fact, if you go into a courtroom, you'll see that this is where the judge sits up on the bench, and then the lawyers' tables will face the judge, obviously, and the barristers will sit facing the judge, obviously, because they're presenting information up towards the judge and towards the jury, if the jury box is over this side, and the witness might be over here, so that they can present to the jury. And the solicitors will sit with their backs to the judge and their backs to the jury on the other side, because it's the solicitor who is, handing paperwork over, going through the brief of evidence, finding the files that the barrister needs, putting, the little tab mark things on stuff so that the barrister can do the job that they need to do. And so the solicitor who will be completely across the case. So two kind of, in a way, types of lawyers. To become a barrister, you have to do special training. So you have to get your law degree. Generally, you'll then work in law, whether it's as a solicitor somewhere or so for a law firm, or you might, be lucky enough to get a job as a judge's associate or something similar. And then you have to what's called read for the bar. So you have to study. You have to do basically a training program, and then you have to pass. And once you have to do another test, and once you pass that, you then have to more or less do effectively an internship. So becoming a barrister is a more extensive process than just being a lawyer. There's more steps to it. So what role do they play? What they are really feeds into then the role that they play. So really like broad role. So if you wanted to talk like a more expansive, like, hey, this is a general responsibility they have, you would just talk about the fact that they support a case. So they use their legal expertise to support the case at hand. So how to present the evidence, how to order the evidence, which evidence to use, how to frame it to a jury, um, how to challenge other evidence, etc. They basically present, do everything in their power to make sure that the case is as good as it can possibly be, both in terms of its preparation and then its presentation. So that's for the prosecution or the defence. If we're looking at the life of the criminal case, you can talk about the fact that they manage pretrial processes and engage in those pretrial processes. So it's legal practitioners for the prosecution, and then probably the defence who will engage in things like plea negotiations. They'll have to attend any pretrial hearings, be they directions hearings, committal hearings for indictable offences, etc. And obviously, we know that the prosecution has a obligation to keep a victim informed. So aspects of that are their responsibility as well, or their role. Specifically in the courtroom, we can get more direct into what they do in a trial. Uh, really important is they'll present evidence and arguments to the court. So some even deeper specifics of that are things like opening and closing addresses. So opening address, hey, I am going to present to you these things. I am going to show you this. This is effectively the argument that I'm putting forward. And over the course of the trial, you'll see evidence that supports that. And then closing, hey, here's all the evidence that we've presented, which supports this argument that we're giving to you, the jury, either as to why this person's done something or as a defence, putting doubt on that. And then with witnesses who are obviously could be the victim, but very, very important aspect of any criminal trial is the giving of oral evidence under questioning. The examining and cross-examining of witnesses will be done by lawyers generally, unless you are again self-represented. And then just things like, making sure that the other party is following the rules. Obviously, the judge oversees the rules of evidence, but if you believe that the other party is asking inappropriate questions, the other party is introducing evidence that they shouldn't, it's the job of the legal practitioner or the role of the legal practitioner to challenge that, to object, as you often see on TV, Famously, Legally Blonde, she gets, well, I object. One of my favourite movies. Things like that responsibility or role of the legal practitioner. So why do you need them? And this is that really important, as I said, addition to the study design, this keyword of the need for legal practitioners. And it's pretty straightforward. Like we've talked about this with access before, about the complexity of the justice system. And effectively, the ins and outs of presenting a case, the rules of court, the language that's used in the construction of our laws, all of it is incredibly complex. There's a reason why people need to go to university for a large number of years to become professionally qualified in this space. The law's hard. Okay? The law is like a different language at times. We call it legalese. And ultimately, a lay person off the street, a regular person who's been accused of a crime, is probably not likely to understand it. So, what access to legal practitioners gives and why we need them is they help you engage with the justice system in an informed manner. So, that should be key, stakeholders. So, they give you advice and information and they explain things to you so you can engage in a informed manner. That's access. They help you present your case, so therefore you can get the best possible outcome. If two parties present the best possible cases, we should therefore end up getting to the true and correct outcome, which we know is fair. So we need legal practitioners for access, we need legal practitioners for fairness, and particularly for an accused person, we need them to make sure that you're not disadvantaged. The prosecution is represented by a lawyer. If you don't have a lawyer, you are going to be at a disadvantage. And we know that equality is all about making sure we address disparity and disadvantage. The other part of it as well is particularly trying to make sure we focus on victims as well. Having the prosecution be trained legal practitioners means a victim doesn't need to manage their own case. So a victim doesn't need to try and find the evidence. A victim doesn't need to try and organise the evidence. A victim doesn't need to try and get court dates, present the evidence in court. We know just giving evidence as a witness is traumatic enough. Imagine if we were trying to leave the entire prosecution up to a victim. So that's where the need for legal practitioners comes into it as well. And that fits in a little bit with the idea of the role of the parties too. But really important here that we tie the need for legal practitioners to those principles of justice because it fits really well. Now, here's a really important case that a lot of you might have heard about before, but this helps us illustrate the need for legal practitioners. Now, this is a guy called I always forget his name, Olaf Dietrich. He subsequently changed his name later on and then got convicted of murder. So overall, not a really nice guy. But anyway, he went to court in 1992 and he was charged with importing heroin into Australia. So he's charged with drug trafficking charges and he was found guilty. 4 charges. He was only found guilty on one of his charges. But he immediately attempted to appeal his conviction, first to the Court of Appeal, which refused to hear his appeal. So then he was able to appeal to the High Court. So a little bit of court hierarchy there, the idea of why do we have appeals, or why do we have a court hierarchy? It's so we have a system of appeals. And Dietrich claimed that his conviction was unfair, so thinking about fairness, because he didn't get a fair trial. And he said he didn't get a fair trial because he was self-represented, aka he didn't have a lawyer. And the really important thing here is that Dietrich tried to get a lawyer. He applied to the Legal Aid Commission, which is the forerunner of what is now Victoria Legal Aid, and they refused. They said, hey, we'll only give you a lawyer if you plead guilty. So if you say you did it, he's like, well, I don't want to. I want to plead not guilty. So they wouldn't give him a lawyer. He applied to the Supreme Court to get legal support. They wouldn't provide it. He went to trial representing himself in the Supreme Court charged with importing heroin. Okay? Now, I actually have a little bit of the transcript from his Supreme Court case. And if we look on the screen here, you'll see, sorry, he went to trial in the County Court, not the Supreme Court, in 1988. And he had this preliminary discussion with the judge. Mr. Dietrich, you're appearing for yourself, is that correct? The judge said. And he replied, I cannot appear for myself. I'm not legally minded. So that idea of access, like I don't know what's going on. He said, I don't understand the system. What is going to happen to me? I've got no idea. I don't want to show any disrespect to this court. I'm not emotionally and mentally fit to conduct my own trial, and I don't want to take the brunt of. I know my own character, I know what's going to happen, and it's going to look bad in front of the jury, and I'm not prepared to take that chance. I'll just sit here mute. So he was basically foreshadowing that he was just going to have to sit there. I mean, he does have the right to silence, but effectively pointing out that he did not have the capability or the capacity to present his own case. And this really dials into that need for lawyers. The High Court overturned his conviction. they agreed with Dietrich and they said, yeah, of course you were found guilty. You couldn't present your case. You didn't have the ability to get a fair outcome because you couldn't put forward the case that you wanted. And it comes down to a little bit about what he wanted to defend himself on as well. He was going to claim that the heroin was planted on him, that the evidence was all fabricated. To do that, there's a high level of forensics involved. He claimed that obviously he wasn't given bail, so he was kept on remand. That impacted his ability to prepare his own case, etc., which are all entirely valid points. And as a result, he was always going to be found guilty because he effectively couldn't defend himself. What is really important, though, is this. A lot of people misread the Dietrich case as this idea of, yeah, you get a lawyer because the High Court said that he should have had a lawyer, so now everyone gets a lawyer. The High Court did not find an absolute right to representation. This is really important. They did not say everyone gets a lawyer. They said, and this is where it gets a little bit legally tricky, and later on down the track we'll talk about this idea of precedent and how the meaning of words can change over time and how judgments apply. But the court basically said if you're charged with a serious criminal matter where you are unrepresented, like Dietrich, through no fault of your own, so you don't just choose to be so you can't choose to not have a lawyer, get found guilty and then appeal. So you're unrepresented through no fault of your own. A trial should be stayed, so adjourned, until you can get representation. The meaning here is that the court can't give you a lawyer and the court won't give you a lawyer, but they're effectively saying that if they think your lack of lawyer and that you want a lawyer but you can't get one through having generally no money, so being poor, the word they use is indigent, I don't quite know how to pronounce it, but effectively if you're so poor that you can't get a lawyer and legal aid won't give you one, and the court thinks that that's going to mean your trial is unfair, they should adjourn the trial. So put a stay on the trial, which means it just pauses and we just wait. And the whole idea is that waiting, that adjourning, puts pressure back onto the government and onto legal aid to then provide the lawyer for you. Because otherwise, particularly if you're on remand, you're just going to sit there. And the idea of someone sitting there on remand when they haven't been found guilty of anything, that's breaching their presumption of innocence, so on and so forth. So again, this decision is not that everyone gets a lawyer. It just helps highlight how important it is to have a lawyer, particularly for really serious matters, because as matters get more serious, they tend to get more complex. And the High Court has clearly said in serious criminal matters, if you can't get a lawyer through no fault of your own, then the trial will be unfair. And that absolutely illustrates the need for legal practitioners. Our key skill is analyze the responsibilities of key personnel in a criminal case. So analyze again, and you can go back and look at the last video for this in more detail, but just wanting to highlight again that this idea of analysis is doing more than an explanation. Is it merely a comprehensive explanation, or does it examine an issue in more detail? And a really important thing to note here is if a question asks you to analyze the need for legal practitioners, you can use words such as this can be seen. So you might be able to explain the importance of having a lawyer, and to turn it from an explanation into an analysis, you might be able to say this can be seen in Dietrich versus the Queen. And you can illustrate how that case shows the need for legal practitioners. So really analysing that key personnel and their responsibilities, their roles. Just remembering as well that we need to focus a little bit on the whole as well discussion side of what they do and what they don't do. So again, solicitors, barristers, slightly different. Barristers examine and cross-examine witnesses, present evidence and arguments to the jury and do the opening and closing addresses. But a real limitation of this is the expense. And solicitors prepare evidence, prepare witnesses, provide ongoing legal advice to the client around the charges. They'll brief the barrister. They'll prepare any paperwork that's required, etc. But again, a limitation of that is that they're expensive. It's really like, again, focus on that idea of expense, which really speaks into our principles of justice. And again, our doesn't achieve is the fact that not everyone can afford it. And if you can't afford it, we know from Dietrich versus the Queen, and you don't get a lawyer, you're unlikely to get a fair outcome. But it's important to note that for that money that you spend, you are getting the best chance to present your case, which should lead to a fair outcome for all parties. And you're getting someone that's going to help you understand what's happening and therefore help you engage. And we know that access is all about engagement in the justice system. And just on equality, there is an argument that the prosecution, always legal representatives or people who are legally trained, they always have more resources, unless you're a squadrillionaire. So therefore, the parties might not be on equal terms. You might always be at a disparity or a disadvantage compared to the prosecution, purely because of their expertise in the area and the fact that they do this all the time. I will provide the link down below, like usual, to the High Court judgment, the one that I flicked to in the middle of the video. Feel free to obviously go and have a read of that and just sort of find the spots where the justices talk about the importance of fairness and the need for legal representation. Ultimately, I would hope that at the end of this, you can really analyse why we have lawyers and why we need them. And particularly with that need, focusing on the idea of fairness, equality, and access, and how legal practitioners provide that. As always, feel free to leave some comments below or any feedback. And we'll see you for video 3.111.